sorry, I can't help it.
Okay, I'd like to start the meeting.
Yeah.
We start with the pledge, please. Pledge allegiance
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Amen.
Now I have the prayer. Dear Lord, we come together today to meet and discuss important issues before our community. We ask for your blessings on this meeting. We ask that your wisdom would guide us in our discussion today. Thank you for this opportunity you give us to serve others. May our actions and our attitudes please you today. We pray these things in your mighty name. Amen.
Amen.
And there's just a couple of announcements. Our October speaker will be Mason County Sheriff Kim Cole. And there's an announcement about O'Malley's in-district hours for September. Hang on. All right. He has 4 locations in the area. He will be available on Friday, September 27th, 10 to 11 a.m. at Ludington City Hall on 400 Harrison in Ludington, and 12 to 1 at Manistee Hall, 70 Maple Street in Manistee. In addition, on September 30th, he will, the City Hall? City Hall? Yes. What did I say? Oh, Manistee City Hall, okay. 12 to 1. Then on September 30th, he will be from 10 to 11 a.m. at Leelanau County Government Center, on Government Center Drive in Suttons Bay. And then 12 to 1 at Benzonia Township Hall, 1020 Michigan Avenue in Benzonia. No appointments are necessary. Those who are unable to attend at the scheduled times would like an opportunity to talk to him may call his office. Did you?
What's the date and time of the Manistee one? I didn't get it written down.
27th.
27th from 12 to 1.
Yeah.
That's September?
Yes.
Okay.
Jack O'Malley
Oh.
at house.mi.gov is his website. And does anybody need his phone number? No. Okay. Okay, now I'd like to introduce our speaker. The Michigan Indigent Defense Commission, MIDC, was created by legislation in 2013. In October of 2018, additional funding was made available to make major changes in the public defender system. In February of 2019, Jared Henry was selected as our first chief public defender serving Manistee and Benzie counties in the newly created Regional Public Defender's Office. Welcome, Jared Henry.
Yes, please. I think I got enough right here. Good evening.
Good evening.
My name is Jared Henry. I am the Chief Public Defender for Manistee and Benson County. A little bit about myself. I have been a lifelong resident of Manistee County. I grew up in Winnetka. We had a Bear Lake zip code, but I went to Brethren High School. I graduated from Brethren High School in 2008. I played football.
Bobcats.
Go Bobcats. Football, baseball, basketball. After I graduated, I went to Central Michigan University.
Whoa, there you go.
Fire up Jeffs. And in 2012, I obtained my Bachelor's of Science in Law and Economics. After that, I went to law school at the University of Detroit Mercy, where I obtained my Juris Doctor's degree. I also had attended Humboldt University in Berlin, Germany, where I received advanced certificates of study in international alternative dispute resolution and mediation. So after I was done with my schooling, I came back to Manistee, studied for my bar exam, passed my bar exam, and immediately went into practice. I was in private practice for about 1.5 years. I did contract work under the previous system that was implemented here in Manistee County, where I was representing the criminally accused, both felonies and misdemeanors. I was doing neglect and abuse cases, juvenile law. Those were all contract cases on top of the civil cases that I was doing as part of private practice. After that, I became the first attorney magistrate for Manistee County. There was previous magistrates, but they weren't attorneys, and the difference is that I was, by law, I could preside over small claim cases. So for about 2 years, I was the presiding magistrate on small claim proceedings. I also did civil infraction proceedings, light enforcement proceedings, Mr. Nelson. I also presided over DNR cases. I would arraign on felonies. I would arraign on misdemeanors. I would set bonds, issue search warrants, arrest warrants. Anything that was really prescribed by statute for a magistrate, I did it. After that, I applied, well, I was also the court administrator for the 85th District Court. It was a dual hat system, if you will. I was responsible for reporting to the state, doing administrative tasks. I was responsible for the employees, evaluations, performance, hiring and firing, along with the district court judge, Judge Brunner. And I was a co-founder of the sobriety court for the 85th District Court. That's a new program. It is up and running. We got grant funded to run that now. I used to be the project manager in sobriety court, and now I operate as a defense attorney on the team. So that is because I switched jobs in March of this year to become the Chief Public Defender. And the Chief Public Defender position was created by Manistee and Benson County as a joint effort to respond to some state indigent defense reformation. And we'll talk a little bit about that later. But today I'd like to talk about 3 points. One point is why defense attorneys are necessities and not luxuries. 2, what has Michigan done to improve the indigent defense services, and why? Why do they go through the effort? And 3, what has Manistee County done specifically in response to these new state mandates to improve the adult criminal defense services? So let's first talk about why criminal defense attorneys are necessities. And I'd like to share a story with you. It's June 3rd, 1961. Someone had broken into the Panama City, Florida pool hall and stole alcohol and some change from a cigarette machine and a jukebox. Later that day, a witness said, "Hey, I saw Clarence Gideon. He was in the pool hall, and he had money in his pockets and a wine bottle in his hand. I saw him get into that cab. It was about 5:30. Based upon that information alone, law enforcement arrested Mr. Gideon. Mr. Gideon was a 51-year-old drifter. They arrested him in a tavern. They charged Mr. Gideon with a felony, breaking and entering a pool hall with the intent to commit a misdemeanor, i.e. larceny. Trial commenced on August 4th, 1961, roughly 2 months after the arrest. Gideon told the judge, "Your Honor, I'm not ready to proceed today. I don't have a counsel, and I really need someone to represent me. Would you please appoint someone to represent me?" This was the exchange by the court. "Mr. Gideon, I'm sorry, but I cannot appoint counsel to represent you. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. And this is not a capital offense. I'm sorry, but I'm going to have to deny your request to appoint counsel to defend you in this case. But, Your Honor, the U.S. Supreme Court has said I'm entitled to be represented by counsel." The court has already made its ruling, and Mr. Gideon was forced to go at it alone. Attempting to mount his own defense, Gideon emphasized his innocence, but it was of no use. The jury convicted him, and he was sentenced to 5 years in prison, the max for that offense. With the aid of the prison library and with prison stationery, Mr. Gideon drafted a 5-page petition to the U.S. Supreme Court. He asked the court, please consider my appeal on constitutional grounds that I was denied my constitutional right to have an attorney present to represent me. The court agreed to hear his appeal. Now at this stage, does anyone want to guess what the first thing the U.S. Supreme Court did? That's exactly what they did. Now we call that foreshadowing when we're dealing with appeals, because we pretty much know what the court's thinking. Now they appointed a famous attorney by the name of Abe Fortas. He later became a Supreme Court justice himself. He argued to the Supreme Court, Your Honor, the first thing that an attorney would do if he was charged with a crime is go out and hire an attorney himself. In fact, that's what the most famous defense attorney of all time, Clarence Darrow, did when he was charged with jury tampering. And if someone as famous as Clarence Darrow and as skilled as Clarence Darrow needs representation, then Mr. Gideon, a layman, clearly does as well. Now, the Supreme Court really wasn't a difficult decision for them, because if you look at the Sixth Amendment, it says in all criminal proceedings, the accused shall have the right to counsel. It was a unanimous decision in favor of Mr. Gideon. Justice Black wrote for the majority. He said, it's an obvious truth that lawyers in criminal cases are necessities, not luxuries. The court then held that the Sixth Amendment guarantee of counsel is a fundamental and essential right, and it's made obligatory upon the states under the 14th Amendment. Citing Powell, which is the famous Scottsboro case, the court reaffirmed that a meaningful right to counsel requires an attorney with the skill and knowledge that even an intelligent layman lacks. Gideon's obvious truth was made very apparent when Clarence Gideon's case was sent back to Florida for retrial. With the aid of counsel Fred Turner, a local attorney, Mr. Turner spent 3 days investigating the case before trial. He skillfully exposed the witnesses of the state and pointed out that the witness, Mr. Cook, was most likely the true suspect, who was looking out for his friends as they had robbed the pool hall. He then called to the stand the cab driver, who said, yeah, when Mr. Gideon got into the cab, he didn't have a wine bottle and he didn't appear to have any money in his pockets. He then put Mr. Gideon on the stand, who professed his innocence and even provided corroborating evidence that he was not the one that had damaged the jukebox and the cigarette machine. The jury was up for 1 hour. He was acquitted of all charges. Now, Mr. Gideon spent 2 years in prison on something he did not do. This was a landmark decision. It not only confirmed the rights of counsel during all criminal proceedings, it also confirmed the rights of counsel during appeal processes. The Supreme Court then continued with subsequent cases like the United States versus Messiah and Miranda versus Arizona that said that the defendant has the right to have counsel present during police interrogations, not just during trial. The Supreme Court then came out with Strickland versus Washington that said that if counsel's performance is inadequate and it falls below an objective standard, and if counsel's performance was adequate and it would have resulted in a different, if it would have resulted differently, then you have the right to a new trial. So what can we learn from these cases? One, we know that defense attorneys are checks and balances on the system. Right? We're ensuring that the government is not overreaching, that they're not attempting to admit illegally obtained evidence. We're effectively enforcing other constitutional provisions. Defense attorneys force the state to follow the most basic principle of law. The presumption of innocence remains intact, and that you must prove someone's guilt beyond a reasonable doubt. Defense attorneys must be skilled and trained. That their skill and experience must meet the nature and complexity of the case that they currently are assigned. Because if they're not, then you might have the conviction overturned at the appellate level. Now, if you have a conviction overturned at the appellate level, ultimately, not only is the person who was convicted wrong, but the taxpayers have to foot the bill of a retrial. Defense attorneys have to act as investigators. Oftentimes they have to investigate their own cases, or if it's outside of their expertise, to hire private investigators. They're also oftentimes required to appoint expert witnesses, not only to contest the state's evidence, but also to corroborate the defense's theory. Now, Michigan has an exoneration statute. It's called the Wrongful Imprisonment Compensation Act. And I believe the last time I read it, if you are found to be exonerated for something that you did not do, then for every year that you spend in prison, you're entitled to $50,000. Now, Mr. Gideon served 2 years in prison. Is he entitled to, well, assuming that this was Michigan, is it fair to give him $100,000? Any thoughts?
I think so.
Right, so, or more. So Michigan and all the states recognize the importance of attorneys. The Supreme Courts have recognized attorneys as necessities, not luxuries. And when we have a system that is dependent on defense attorneys as being such a vital part of the system, oftentimes we want to conduct studies to make sure that everything is running smoothly. So let's move on to the reform in Michigan. What happened? In 2006, under concurrent resolution 39, the Michigan legislature, along with the state bar, had requested that the National Legal Aid and Defender Association conduct a year-long study on 10 representative counties in the state of Michigan and determine how well are their criminal defense systems operating. Now, when you conduct a study, you want to have a baseline measure. You want to have some policy by which you can grade these counties. And I just passed out the American Bar Association's 10, I'm going to use the words best practices because I forgot what the title is, but those are the 10 standards by which the NLADA used to grade these counties. Hannah, would you hand me one? Okay. So we looked at these 10 standards, and they, through a committee, chose 10 counties in Michigan. Those counties were Wayne, Marquette, Chippewa, Alpena, Bay County, Oakland, Shiawassee, Jackson, Ottawa, and Grand Traverse. Now, the NLADA in 2008 published their study. It was called A Race to the Bottom: Speed and Savings Over Due Process, a Constitutional Crisis. Anyone want to venture a guess as to what was contained in that study? It was not good. Okay? They indicated that all 10 counties failed to meet the 10 standards found here in this form. Some reports called it constitutionally inadequate. The findings said that the minimal standards were not met. They found that judges were handpicking defense attorneys. Lawyers were appointed to cases for which they were not qualified. Defenders were meeting clients on the eve of trial and holding some non-confidential discussions in public courtrooms. Attorneys were failing to identify obvious conflicts of interest. There was failure of defenders to properly prepare for trials or sentencings. There was inadequate compensation for those appointed to defend the accused, and the lack of sufficient time, training, investigators, experts, and resources to properly prepare a defense. They also ranked Michigan 44th out of 50 states in terms of funding. We were 38% less than the national average. We were roughly $7.35 per capita, and we're spending $74 million a year. We were also one of only 7 states where the local counties were responsible for 100% of the funding. The report indicated that if we were just to meet the national average, we would need to spend another $50 million. Okay, that's just to hit the average. Now, for those of you who, like me, love studying this stuff, you can find this report. It's online. You can go to the Michigan Indigent Defense Commission webpage, click Resources, and under the Resources tab, you will find this report. And again, it's called The Constitutional Crisis and the Speed and Savings Overdue Process. Now, that's what the report said. I personally don't think Michigan was that far behind the 8 ball. I think for the most part we were doing pretty good for what we had. But the report basically said we need some improvements. And the report was published nationally. It was kind of, like I said, it was a black eye. Right? So Governor Rick Snyder decided to sign an executive order. He signed it on October 13th, 2011, and he established the Michigan Advisory Commission on Indigent Defense. This commission was tasked with analyzing existing data that is needed to assist policymakers in making decisions on the appropriate funding and staffing levels to ensure effective public criminal defense services. He said, the commission shall make recommendations to both the governor and the legislature for improvements to the system of providing legal representation for indigent criminal defendants as follows. 1, any improvements must be fiscally responsible, cost-effective, and consider the current economic condition of the state and local units of government. 2, any improvements must be responsive to jurisdictional variances and local community needs. 3, any improvements must ensure that indigent defense is free from undue political interference and conflicts of interest. 4, improvements must seek to ensure that the right of counsel is delivered by effective counsel at each critical stage of the proceeding in a manner that is consistent throughout the entire state. And 5, improvements must aspire to ensure that government-funded criminal defense attorneys are sufficiently trained and supervised, appropriately qualified, and adequately compensated. So this commission was made up of attorneys, defense attorneys, prosecutors, judges, different types of associations. They were all invited to come, people were invited from counties to come and speak to this commission about what they were experiencing. And even some representatives from the 10 counties that were studied under the NLADA came and tried to defend their counties, but ultimately conceded that there were some areas for improvement. The commission then reported the following. So in addition to the study, the commission reported to the legislature the following. Here are some common examples of ways in which the minimum standards are not met. 1, there's no standards to control attorney workloads. There's few local systems of which the commission was made aware that required continuing legal education of its defense attorneys or systems to evaluate performance. Now, I can contest when I get out of law school, I did not have to take continuing legal education. I now have to take continuing legal education as a result of the legislation. There were some discrepancies as what amongst the different systems as to what constituted adequate funding, what constituted adequate representation. So there was no uniformity. Also reports that the Michigan taxpayers are exposed to millions of dollars in unnecessary expenses in the most egregious cases, sometimes simply because of simple sentencing errors which could have been avoided. The State Appellate Defender's Office indicated that the taxpayers were also exposed to millions of dollars annually for simple appellate issues. The commission also said that there's really no data that we can go off of because there hasn't been any measuring devices administratively like there have been in the court systems for the State Court Administrative Office or the Prosecuting Attorney's Office because we weren't really studying this stuff. So we've got all of these recommendations, we have all of these reports, we have the NLADA study. The Michigan legislature was then forced to act. And in 2013, they passed the Michigan Indigent Defense Commission Act. Now, this didn't get rolling until 2017. So what happened between 2013 and 2017? I mean, 4 years. Government should be a little bit more responsive than that, right? Just hurry up and wait. So the best consensus that I could figure out from my research was it went through some court battles. It was initially, from what I could tell, the commission that was going to be set up was going to be a branch of the Supreme Court. The Supreme Court came back and said, no, we don't tell prosecutors what to do. We're not really going to tell defense attorneys what to do. It's really a separation of power issue, and you guys got to go back to the drawing board, make it part of the executive branch if that's what you want. So that's what the legislature did. They created the MIDC and they put it under the Licensing and Regulatory Affairs. And the MIDC met in, I believe, 2017, 2016, and they passed their first 4 standards. All right, so the Act says that the MIDC is to make some standards, and all of the state has to write compliance plans as to how they're going to meet those standards. So the first 4 standards were passed. Standard 1, education and training. Defense attorneys have to take 12 credits of 12 continuing legal education credits a year. They have to have enough experience to handle the complexity of the case presently before them. Right? You're not going to assign a first-year law graduate to a capital offense. 2, initial interviews. Right? One of the reports from the NLADA was that lawyers were meeting the clients at the eve of trial. The new standard is attorneys have to meet their clients within 72 hours of appointment, or as near as possible 72 hours, even if they're in custody. Investigation and expert witnesses. We should have a budget to hire expert witnesses, to hire private investigators, and that should not be tied to court approval. Now, in past practices, when I was under the previous contract here in Manistee, defense attorneys were just getting paid an hourly rate or a flat rate. And if we needed an expert witness, we had to go to the court and petition them and say, please, Your Honor, we need $1,500 so I can go hire this expert in order to make my defense. And the court would say, well, I can't give you $2,000, but I can give you $1,500, right? They had a budget that they had to follow. And oftentimes they would break their budget and then they would have to go in front of the county board, right? It was 100% locally funded indigent defense. And also, right, that we have to make plans to have attorneys at first appearances. That means at arraignment. So as soon as someone's arrested and is charged, defense attorneys now have to be present at arraignment. Why is that necessary? You're charged with a crime, and under the old system, defense attorneys weren't really getting their appointment until after the arraignment, because it was at the arraignment where the judge was determining whether someone was indigent, right? And so there would be the determination of indigency. There would be the arraignment. They would advise of the nature of the charges against the defendant. And then they would fill out a financial statement, and the defense attorney would get the case prior to a pretrial. But at that time, it's really, you know, we missed the chance to argue bond. You can argue bond at any time, but we missed it, you know, right when the arrest occurred. And someone could languish in jail for longer than necessary if a defense attorney isn't there to make a pitch for bail, right? Because laymen don't know what to argue. So we had the first 4 standards, and the county boards, so both Benzie and Manistee, got together and said, how are you going to write a compliance plan to meet these 4 standards? The law says, under the MIDC, that the compliance plan has to say how we're going to meet those 4 standards and how much money it's going to cost to do so. And the formula was a local share dollars, which was a fixed number. Anything above that local share is going to be grant funded by the state. Our local share was calculated by the 3 fiscal years prior to 2013, which is the passage of the act, how much money was being spent on defense counsel minus how much money was coming in from partial reimbursement from defendants. So oftentimes the court might say upon conviction, okay, you owe us $250 for reimbursement of court-appointed attorney fees, right? The court might have paid $300 out, was expecting to receive $250. They might have only actually received $100. So you take your fiscal years, you would look at what you spent, and then minus what you got back, and that's your fixed local share dollars. Anything above that is to come from the state, which is good in some sense because the state now has more money to put towards indigent defense pursuant to this act, because in 2018, for this fiscal year, they passed an appropriation bill of $87 million to fund this program. This year, the current proposal is $83 million. It's less because of the capital improvements that were needed were no longer necessary. But we don't know if that's going to come through yet. My understanding is the state has yet to pass that appropriations bill.
You know, it must be brought up through what department, because I don't ever recall hearing about this through the county commissioners and their budgetary process for the county, you know, the $11 million that they're budgeted for the county. It must be tagged on to the what department?
So the state funding is going to be under licensings and regulatory affairs. And the county stuff, the discussion would be under general fund dollars. So there's a new fund created in Manistee County. It's I think it's either a 259 or 260 fund. It's the Indigent Defense Fund. The amount of money that's transferred out of the general fund is going to be whatever that local share calculation is for Manistee. Okay. It'll generally be discussed under the committee of the Public Defender's Office. There's a new Joint Public Defenders Committee. It'll get discussed there and then brought up to the board for full approval.
You know, it sounds to me like this is a new, but back in the early 70s, I used a public defender to get some money that a company owed me that they didn't want to pay. And it sounds just like the organization that you have now, but maybe it was more local and less statewide. I don't know. But I called up, I just remember contacting the public defender, and then 2 weeks later I get a check in the mail. Okay. Not from them, but from the people that owe me the money. And I'm just wondering how this was, you know, you make it sound like it's new, but it wasn't new to me.
So there was a previous public defense system, but it was contractual. The defense attorneys contracted with the individual courts to provide their services. And remember how we talked about under these standards, you don't want any undue influence from the courts or any other branches of government, right? I mean, the prosecuting attorney's office has a contract with the court to take cases on. And so you wanted to pull some independence in our system. So they've switched from the contract system to a public defender's office.
So this was probably a contract.
My suspicion was it was, from what you're talking about, it sounds might have been a contract. Some counties had public defender's office. I don't know how
This
they...
was up in Marquette, so it was a fairly populated area.
They probably had a public defender's office.
I think they did.
I don't know how they set it up, but Marquette was one of the people studied by the NLADA, and they claimed that Marquette was not meeting the muster. Right, so.
Are you going to give us an overview of the activity since you started?
Sure. So that's kind of what Manistee and Benson County has done to get a new system going. We have 2 physical offices, 1 physical office in Manistee, 1 physical office in Benzie. We have 1 chief public defender. I have 2 chief assistant public defenders and 2 associate public defenders. I also have 1 office administrator, and if the budget comes through this year, I'll have another office administrator. We take on, and we're interchangeable, so although we have 3 attorneys in the Manistee office and 2 attorneys in the Benzie office, the way it's set up is Manistee can take Benson County cases and Benzie attorneys can take Manistee County cases. It's a joint office. We operate on a single case management system, so we can see what each other's schedules are, and it's been working very well.
Where are these cases referred to you from?
They're referred from by the court, right? So the court makes an indigency determination and then appoints our office.
Which court?
It would generally be the district or circuit court, either one, depending on what's being charged. Yes.
Yes, when they did that study with the 10 counties and so forth, was I guess several cases then gone to appeal because they didn't get what they considered a fair trial.
I don't know that. I would suspect probably not, because I would guess that at that point the appeals period would have already lapsed. Now in the Gideon case, I think, if memory serves me, because there was multiple convictions on people who were denied the right to have counsel upon request, I think there might have been 2,000 people that were freed, but it was because of a constitutional violation. And
Well, they made a movie on this guy.
I think they did, yeah.
So your office gets its money mostly from the state, but it's supplemented through the county?
It's partially funded by the county and partially funded by the state, but we get more money from the state than we do the county. Yes. Does that make sense?
Yeah. I'm just trying to, because I don't ever recall hearing about that through the budgetary process.
And maybe the reason being is because we submit our grant first to the state because we don't know what they're going to approve first. And then I submit a number to the county, which is simply our local share, which is a fixed number. And then they would include that as part of their general fund transfer out. So if you were to look at the general fund transfer out, you should see about $191,000. And that would go towards the Indigent Defense Fund for the next fiscal year.
So who's your boss?
So I report to the county controllers and the board of commissioners. I'm contractual with the county.
So you report to Dave Kepler?
Yes, and Mitch Deesh and Benzie County. I report to both.
And your office is in the courthouse, is it?
It is, right across from the Registry of Deeds office. It used to be the old planning department.
Oh, plan, yeah.
And the new planning across the...
Yeah. And you've been there for how many years?
Well, since it started, this office started, which was March of 2019. It's a brand new office. It's a brand new program.
Yeah, but you've been here for how long?
I've been here for my whole life, but practicing almost 5 years.
An individual charged with a crime, is he better off with your office or with a private attorney?
Well, whether he can get my office depends on whether or not the person's indigent.
Well, let's say he is
Of
or
course, I'm gonna
isn't.
say my office, I mean,
Let's say he is or isn't.
I'm sorry?
There's two people commit a crime. One can afford an attorney, one can't. They're gonna go in together, I'm guessing.
Then the one who can't afford an attorney will come to my office, and the one who can would have to go retain.
So who's gonna do better? Is there any statistics?
It depends on the facts of the case. Yeah, I mean, you don't, how someone does is not dependent upon how much money they have, or I mean, it should really depend on the facts, right? Right, what the evidence is.
How do you become indigent?
Well,
Like, who establishes what is indigent and what isn't?
so, that's a very good question. There's not that many, I mean, I don't think the guidelines on that are very clear and concise. One thought is it depends on whether or not you meet the poverty guidelines. Another thought is do you receive any types of means-tested assistance by the state or federal government. But the court ultimately decides indigency. What they look at is not only what you bring in, but what your expenses are. You can work a full-time job and still be found to be indigent. If you make minimum wage and you have expenses that are at or near what you bring in, you're likely going to be found to be indigent.
As a student, were you required to study constitutional law?
Was I required to?
Study constitutional law?
Yes, it's a requirement, and it's bar tested.
Tuesday was Constitution Day. Do you have any idea of how many schools did not teach the Constitution on that day? They're required by federal law to do it.
I have no idea. I don't know who's taught constitutional and who hasn't.
Any school district that receives federal aid must teach the Constitution on that particular day.
In my opinion, not only must they, but they probably should. They should. It's a moral question.
That day, September 17th, as specified in the law. Well, it should. One day,
I'm free to speak to any students who want to talk about common law. If I was ever invited to a
we
school,
were
or
contacted.
if I was contacted, I would talk to them. Absolutely.
I still want to hear how many cases have gone through your joint offices, Benzie and Manistee.
I was asked this morning at the annual summit. I guessed around 400, I think. I went back and looked at my numbers. I am between 350 and 400 right now since April of this year. So April, May, June, July, August, partial September, 5.5 months. About 350 cases to 400.
And you said you just won cases this week.
It was Lisa Dahl out of my office. Yeah, she took a case to jury trial. The person was acquitted. Jury was out for about an hour.
What has this done for the number of people that have been, say, thrown in jail because they weren't able to post bond? Has that whole scenario shifted? Because the lawyer is now required to be at the arraignment.
We are now required to be at arraignment. I don't have statistics on that specifically as to how many more people than previously because it was never tracked previously. But in my personal experience, I think it's actually working. And we're actually going to go under an audit process in October by the state. They've passed an audit policy. They're going to be joining us in the first or second week of October. And that's one of the things they're going to be looking at. But they were previously here in May, and we passed all 4 standards informally. We have a MIDC manager who comes in and works with us, talks to us, and tells us what they think. And we've passed. I mean, we did a good job. Now, there's going to be 4 more standards that are likely to pass in the next year, and I think we're actually in compliance with those as well, based upon the face of the language. So Any other questions for me? I mean, it's-
You and I discussed briefly before the thing started that when a defense attorney says, my client is a wonderful, wonderful, I mean, I cannot explain how wonderful he is. Does that have any influence on the judge? He's not under oath. He can say whatever he wants.
well, the defense attorney's statement's not evidence, right? And it's generally conceded, it's generally argument. But we are officers of the court. We're not allowed to lie to the court.
Okay.
So when we say, you know, I believe my client to be a very stand-up person, this is the first offense, going to be a lifelong citizen of the community. Yeah, that's going to go a long way. Now, if I have a client who has 10 previous convictions and I stand up there and tell the judge, yeah, you know, he's a good guy, the judge might say, okay, so.
Can your office be used for legal advice?
We only give legal advice to clients. The state is talking about allowing us to take on expungements, and the state's also talking about allowing us to get involved with sobriety court as part of our services.
What about just advice? We'll scratch the legal end.
I don't know what the state would say on that. I probably suspect probably no, because then we're giving advice to people who may or may not be indigent.
So,
Yeah.
you're paid by us, so.
Yeah, I'm right there with you.
I mean, it's just hard to get advice on legal things when you're not familiar, number one, with the system, and number two, with all the laws that regulate. And, you know, you don't always, every time you pick up the phone and call an attorney, you know, it's a $250 bill. It'd be nice to have somebody you could just call up and say, you know, this is my situation, what could I do?
There are agencies that do that.
What agency might that
Called
be?
legal aid, Michigan Legal Aid.
Yeah, but they're,
I don't know much about it other than that they do give advice and stuff like that. I don't know specifically what you're referring to. I know they take on civil cases, some criminal cases, and what kind of matters. You call my office, I'll be able to get you in touch with them.
You said you were involved in the sobriety court?
Yeah.
Is that like along with the drug court, like Traverse City is?
It's right along the same guidelines. The sobriety court is really tied to people with alcohol use disorder. We also follow people through MAT programs and stuff along those lines. The state funding that we have for that is really tied to drunk driving cases. But I believe the circuit court's currently in the process of getting a drug court specifically for opioids and other types of substances and treat those separately. But yes, it's sobriety court. It's really focused on alcohol.
How did it work? I mean, did you find it to be a success or?
So it's been going on for about 5-6 months now.
Oh.
The way that I describe sobriety court is it's really enhanced probation. You've got more supervision, more testing, more drug testing. You have more treatment. We have a team that meets confidentially. And when we discuss alternative treatment options for people, if someone slips up, then we discuss sanctions other than just jail. They work one-on-one with a case manager who helps them through their treatment, and our case manager is unbelievable. I mean, this person has been doing treatment for I think his whole career. He can actually teach some of the courses like Smart Recovery, and so I mean it's a really nice program. And we work with agencies like Catholic Human Services and Community Mental Health. We also will allow someone into the MAT program who works with Dr. Baker with addiction services, medicated assisted treatment.
what's your yearly budget?
Our yearly budget is just under 800 grand, about 725,000.
Part of that's paid by Betsy, part of it's paid by.
Yes, Manistee, part of it's paid by Manistee, and the remainder is paid by the state. Yes. So you've got the Manistee local share, the Benzie local share, and anything above that comes from the
So
state.
did you turn in your budget just recently for Dave's? Because they just approved the budget.
Dave's had my budget for, yeah. Yeah, actually, I'm the first one to submit because the state requires that I submit my budget to them in May, or before that, April, when you had it submitted, so. Then Dave knows what my local share is going to be based upon that, and he just includes that as part of the general fund. General fund transfer out. Any other questions? Okay,
Thank you.
thank you.
You know, I didn't realize that.
That's all right, I just want to say thank you very much. This is a side we don't usually hear about or see about.
No, it's amazing, it's amazing
Complex and yet,
how complex it is, yeah.
yeah. So, we appreciate that.
Well, thank you for letting me speak here.
Does anybody have any other announcement, anything miscellaneous they want to say? Okay. Remember, our next meeting is October 17th with the Mason County Sheriff, Kim Cole. Okay, thank you very much for coming today, and we are adjourned.
Wasn't it on Homeland Security with the sheriff?
What?
His subject?
Border security.
Border security?
Border security.
He's a quite the
Yes, the primary topic will be discussion about border security. He, let me read the rest of this little blurb here. He recently returned from a national conference in Washington, D.C. on border security and related topics. He was also appointed by Governor Snyder in 2017 to the state 17-member marijuana advisory panel. There will be times for questions and answers of whatever concerns we have. Right? So let us see you next month, same place. Thank you. Thank you.
Well, we got the sun going down, looking past the water tower over there.